Let's take a look at administrative hearings. Simply because a proceeding qualifies as an adjudication under the APA doesn't mean that trial-type procedures must be used. The APA mandates trial-type procedures only whenever another statute specifically requires them. A congressional mandate for a hearing is not likely to be construed as requiring a trial-type hearing. Congress must clearly state the right to a trial-type hearing is granted. If a full trial-type hearing is not required, an agency may use another form of hearing within the limits of due process. Such hearings are similar in many respects to court trials. The parties make opening and closing statements, they're permitted to call and cross-examine witnesses, and they may introduce other evidence and make objections. An administrative law judge or other officer presides at the hearing. However, as you'll learn, some important differences exist between judicial trials and administrative adjudication. In federal and state courts, rules of evidence govern whether testimony, exhibits, and other evidence may be admitted. Evidence that is untrustworthy, irrelevant, or unduly prejudicial will be excluded from trial under various rules. A presiding officer of an administrative hearing may admit hearsay and other evidence that would be excluded from a judicial trial unless the agency has a rule of evidence that requires otherwise. Although agencies are not bound by court rules of evidence and therefore may admit incompetent evidence, their decisions should not be based on such evidence alone. Common law, recognizing the importance of privacy of certain communications, developed privileges prohibiting the government from compelling disclosure of such communication. Judicial notice is a method of avoiding the need to prove the well-known or the obvious. The purpose of judicial notice is to save time. A hallmark of the U.S. judicial branch is independence. Article 3 of the Constitution creates the Supreme Court of the United States and such inferior courts that Congress decides to create. It's the basic tenet of due process that have a fair hearing and there must be an unbiased and neutral ALJ. 3 issues are raised in this context: interest, bias, and prejudgment. As a general proposition, parties have the right to be represented by counsel in administrative adjudications. In most cases today, the right is established by statute or rule. The final stage of the adjudicative process is the issuance of a decision. The APA requires that all parties in an adjudication be permitted to submit proposed findings and conclusions before any decision is rendered. Finally, you may want to attend an administrative hearing as an observer to get an idea of what it looks, sounds, and feels like.